Hello, everyone. Welcome to my video webinar on depositions and other modes of discovery. Thank you for registering for this webinar. This video will be in two parts, and this is part one. Usually, when there is a webinar, the participant can access the lectures only on the day of the webinar. After the webinar, the participant can no longer access the video. However, in the case of EasyLaw Online, I'm giving you full access to the video webinar for a total of 7 days. In this way, you can maximize the fee of 200 pesos that you paid to register for each segment or part of the webinar. So since this series will have 2 videos, then you will be entitled to full access for a total of 7 days for each video. This is how we are packaging all EasyLaw online video webinars. Part 1 will be available starting today. Part 2 will be available starting around 2 days or 3 days from now. So wait for it. Papadalhan po kayo ng link so that you will be aware when you can already access the video. Now, before proceeding with the webinar, let me first introduce myself. I am Rosario Ramos Olivas, and you can call me Attorney Chato. Well, I'm 63 years old. I've been in practice of law since 1988. I graduated with a Bachelor of Laws degree from the University of the Philippines College of Law, which is 36 years ago as of the day of this recording. I graduated with a Bachelor of Arts degree in journalism from the University of the Philippines, Diliman, 1981. I am at present the Associate Dean for Clinical Legal Education of De La Salle University's Tañada Diokno School of Law. I am a faculty member of the LSU's Tañada Diokno School of Law, teaching mainly remedial law, practice court, legal forms, and clinical legal education subjects. I'm also a regular lecturer of the Chan Robles Bar Review Center on Remedial Law. I'm also a regular lecturer of the Chan Robles LawNet for mandatory continuing legal education. And occasionally, I lecture for Access MCLE provider, as well as the University of the Philippines, and sometimes the Integrated Bar of Quezon City. Now, with this introduction, let's now talk about depositions and modes of discovery. The way I would like to discuss this topic is to go through important Supreme Court decisions from which we can extract important legal principles on modes of discovery and such as deposition. In other words, I would like to harness important lessons from jurisprudence. So by way of an overview, we will deal with 5 different modes of discovery. These are, number 1, depositions. Number 2, interrogatories to parties. Number 3, requests for admission. Number 4, production or inspection of documents or things. Number 5, physical or mental examination of persons. We're also going to discuss sanctions that can be imposed upon persons who refuse to comply with the rules and court orders concerning these modes of discovery. For today's video, nakapili ako ng 4 na kaso from which we can gain very important lessons. And these are, number 1, Fortune Corporation versus Court of Appeals and Intermerchants Corporation. This is GR number 108119, January 19, 1994. The second case is People of the Philippines versus Hubert Webb, GR number 132577, August 17, 1999. The third case is Harry L. Go et al. Versus People of the Philippines and Haidan Company, GR number 185527, July 18, 2012. And the last one, this is the case of Mary Jane Veloso. It's entitled People of the Philippines versus Maria Cristina Serio and Julius Lacanilao, GR number 240053, October 9, 2019. So, punta na tayo sa case number 1. That's Fortune Corporation versus Court of Appeals and Intermerchants Corporation, 1994 case. Itong case na to ay importante to because it explains the purpose of modes of discovery, the advantages of one mode of discovery over another. So tingnan natin, pag-aralan muna natin yung facts of the case, which are quite simple. It's an action for breach of contract filed by Fortune Corporation against Intermerchants Corporation before the regional trial court. So Fortune filed a complaint. The defendant filed the answer. After the answer was filed, Fortune Corporation, the plaintiff, served the defendant with written interrogatories. This is a mode of discovery. Now, ano ba yung written interrogatories? These are interrogatories or questions that are sent to the other party for the other party to answer under oath. Okay, so Intermerchants answered the written interrogatories through its chairman, Mr. Juanito Tiope. And then after the written interrogatories were answered, edi syempre joint na yung issues kasi meron ng complaint, meron ng answer. Di ba ang rule natin sa civil procedure, after the answer has been filed, the issues will be joined. Okay, so after the issues are joined, the next step is for the court to set the case for pre-trial. So there were several dates that were set for pre-trial, and during these settings, okay, Fortune served upon the defendant a notice to take deposition upon oral examination. So tandaan natin, meron ng written interrogatory, sinagot na. Tapos yung Fortune, nag-file pa ng notice to take deposition. And dun sa notice nilagay ng Fortune, when will the deposition be taken, where, and who is going to be deposed. So the person who will be deposed or the statement will be taken is the same person, the chairman of the board of the defendant, that's Mr. Tiope. And the basis of Fortune in filing this notice is Section 15 of Rule 24, which is deposition on oral examination. So yung defendant, dahil nagkaroon na ng written interrogatories at nasagot na, nag-object yung defendant. Nag-file siya ng urgent motion not to take deposition / vehement opposition to plaintiff's notice to take deposition upon oral examination. So may mga reasons na binigay yung defendant. Okay? Una, yung Fortune already availed of one mode of discovery, written interrogatories, and it practically covered all the claims, counterclaims, and defenses in the case. Second, Fortune did not give any sound reason why it has to take the oral deposition of the same person who answered the written interrogatories. Next, the taking of the oral deposition would cause annoyance, embarrassment, and oppression upon the prospective deponent, Juanito A. Tiope. Number 4, the intended deponent, Mr. Tiope, has no intention of leaving the country. And 5, he is available to testify in open court if required during the trial on the merits. So, pause lang muna tayo dito. Ang tawag dun sa tao na kukunan ng statement is the deponent. At this point, that person is not a witness. Because a person becomes a witness when he is presented in court, when he is presented on the witness stand after he takes oath. Pero ito, since the deposition is taken out of court, and it is not presented during the trial, the one whose testimony or whose statement will be taken is not a witness. He is a deponent. And his statement is not a testimony. It is a deposition. So, malinaw kapag deposition, it is not taken during the court proceedings. It is not taken in front of the judge in open court during a trial. All right? So, pwedeng gamitin siya in court later, pwedeng hindi. Pwedeng gawin lang siyang tinatawag na source of the evidence or fishing expedition, which is what it can be. And that is allowed by the rules on modes of discovery, kaya nga discovery. Ang purpose ng modes of discovery is full disclosure on the part of both parties. Ano ba yung kanilang legal position? Ano ba yung kanilang mga ebidensya? It is to prevent surprises. So that's one of the important reasons why depositions are taken. It is full disclosure so that everybody's cards will be laid on the table. All right, so after intermergence, the defendant filed an opposition. The trial court issued an order, and the order states the deposition is not going to be taken for the following reasons. First, the proposed deponent already answered the written interrogatories of the plaintiff. Next, he has already said that he is available to testify in court when he will be required to appear. And the third, to allow the deposition will deprive the trial court of the opportunity to ask clarificatory questions on the proposed deponent who appears to be a vital witness in the case. Okay, like I said, the deposition will not be taken before the judge that is hearing the case. So yun yung reason ba't sinabi ng RTC. It will deprive the court of the opportunity to ask clarificatory questions. Saan ito take yung deposition? Before whom? Before an officer, a person who is authorized to administer oaths, like the judge in another sala, or a notary public, or an officer who is authorized to administer oaths. All right, so when the regional trial court issued the order that the deposition will not be taken, what did Fortune do? Fortune filed a petition for certiorari with the Supreme Court. The Supreme Court referred the case to the Court of Appeals, and the Court of Appeals denied the petition for certiorari. So Fortune filed a motion for reconsideration, which was also denied. Yung CA, inuphold niya yung ruling ng regional trial court. So what Fortune did was to file a petition for review on certiorari with the Supreme Court. So ano yung isyong present ng Fortune dito sa Supreme Court? The issue is, can a party who has already availed of a mode of discovery, as in this case, written interrogatories, subsequently avail of another mode of discovery, even when the deponent is ready, willing, and able to testify in court? And the answer of the Supreme Court is yes. Yes. Pwedeng magkaroon ng another mode of discovery, such as the taking of oral deposition even after written interrogatories have been served on the other party, and the other party has already answered the same. So ano yung ratio decidendi? Ano yung reasoning na binigay ng Supreme Court kung bakit ito pwede? Okay? Sabi ng Supreme Court, meron namang mga sanctions sa availment ng modes of discovery para maging untrammeled ang mode of discovery. Ang general rule kasi, liberality. People are supposed to disclose their legal position, their evidence. Modes of discovery should be untrammeled as much as possible kasi nga, ang goal ng trial, ang goal ng litigation is for the parties to disclose their evidence and legal position as much as possible. In other words, to lay your cards on the table para pantay ang labanan. So hindi pwedeng tinatago yung ebidensya, hindi pwedeng sinusuppress, kasi paano magkakaroon ng fair and just ruling kung hindi naka-lay down lahat ng mga evidence and legal position. So yon, ang rule sa mode of discovery is liberality. There are times when sanctions can be imposed by the court for serious violations by the party or by a proposed deponent. For example, ito naka-enumerate sa Rule 29, ano ba itong mga sanctions na to? Pwedeng ma-dismiss yung action or proceeding dun sa party who is violating the rules on modes of discovery. Pwedeng mag-render yung court ng judgment by default against the disobedient party. Okay? Pwedeng mag-file ng ma-cite for contempt or mapa-aresto yung party who is deliberately disobeying the orders of the court or violating the rules on discovery. Pwedeng pagbayarin siya ng reasonable expenses incurred by the party who wants to avail of or to compel discovery. Bakit? Kasi magkakagastos yung party who wants to avail of the mode of discovery. Pagkatapos magdi-disobey lang yung kabilang party, iba-block niya, hindi niya papayagan na matuloy yung discovery. So nag-incur na ng expenses yung party in good faith. Therefore, the party in bad faith should be responsible for reasonable expenses incurred by the party in good faith. And then another sanction will be taking the matters in part into as established in accordance with the claim of the party seeking the discovery. Another sanction will be to refuse to allow the disobedient party to support or oppose designated claims or defenses. And then the last is striking out pleadings or staying further proceedings. Basta ang rule, the party in bad faith, ganun naman sa law, di ba? The one who is in bad faith will be punished. The one who is in good faith will be rewarded. So, tandaan niyo yung principle na yan. And this applies as a general rule across different branches of Philippine law. Okay? So, ganun din pagdating sa modes of discovery. Ngayon, may mga limitations naman ng discovery. Kahit dun sa situations when they can be undertaken without leave of court, pag-aaralan natin, ano ba tong modes of discovery na to? Pero for now, ano muna yung mga limitations to discovery? Number one, bad faith. Kung ang mode of discovery is being availed of in bad faith, hindi pwede. Number two, if it is intended to annoy, embarrass, or oppress the person who is subject to the inquiry. Or number three, if the questions are irrelevant. Or number four, privileged communication. Siyempre, kapag privileged communication, according to the rules on evidence, may non-disclosure requirement yan. Hindi pwedeng pilitin mag-testify. Pero, kailan naman unrestricted ang discovery? Apat. Number one, relevant. Number two, not privileged. Number three, good faith. And number four, within the bounds of law. Okay. So, may mga situations, syempre, na pwedeng mag-issue ng order ang court not to take deposition, pero hindi basta-basta ganun lang. There must be a notice and it must be for good cause. Sino ang magsasabi na there is good cause? It is the court in the exercise of judicial discretion. So wala siya talagang listahan ano ba yung good cause for not allowing deposition. Pero it will be subject to the evidence presented by the party who claims that there will be some injury if the deposition is going to be taken. So a person who does not want the deposition to be taken is actually seeking a protective order. Okay, so backtrack lang tayo ng konti. The general rule is liberal ang mode of discovery such as deposition taking. The exception is among those that I mentioned earlier, pero talagang ang general objection dyan will be there is no good cause for taking the deposition. Okay, so the one who wants the deposition to not be taken is actually asking for an order from the court to prevent the deposition, and this is what we call a protective order. Ang may burden of proof is the one who is moving for the issuance of a protective order. So another legal principle, guys, the movant is the one who generally must prove why his motion should be granted. So hindi lang basta magmo-motion verbally, mag-allege, hindi lang basta ganon. There has to be a factual support, an evidentiary support, or a legal support for the motion. There must be a strong showing that there must be a valid basis for denying the right to take a deposition. So basta kapag allegation lang, it's not enough. Not enough good cause or allegation that the deposition will be taken in bad faith, that's not enough. Why? It's just an allegation. An allegation that it will expose the party to forfeiture, not enough because it's just an allegation. Or the mere fact that a deposition has already been obtained, the mere fact na yung information na kailangan was already obtained through other means like a bill of particulars, written interrogatories. That's not enough because it is possible that the matters required to be disclosed in an oral deposition will be different from the matters that were disclosed in the Bill of Particulars and in the written interrogatories. The mere allegation that the deponent knows nothing about the matters involved is not enough. It's just an allegation. There has to be an actual statement under oath when the deposition is taken that the deponent really does not know anything about the matter being asked. Mere allegation that it is protected by copyright or if there are trade secrets, that's not enough to prevent the taking of deposition. Okay? Or that the transactions were already confirmed in writing. That's not enough. That's what the Supreme Court said. So in this present case, the defendant was not able to establish good cause to secure a protective order. Okay? So ano ba yung scope of discovery? Yung scope, like how far can one go in seeking information? Again, the Supreme Court said this is liberally construed in order to provide the litigants with information essential to the expeditious and proper litigation of each of the facts in dispute. Liberal. So ang general rule sa mode of discovery is liberality. In terms of applicability of the different modes of discovery and in terms of the scope of the information required. And then also, the Supreme Court was careful to point out that although madaming modes of discovery, these are not mutually exclusive. These are not alternative. They are intended to be cumulative. So kapag may written interrogatories, pwede pang magkaroon ng oral deposition. That is not prohibited. Now, when do we use the different methods of discovery? Okay. Maganda tong case na to kasi sinight ng Supreme Court. Yung advantage of written interrogatories, advantage of oral examination. So if you study this, you will be able to know kailan nyo gagamitin yung written interrogatories, kailan nyo gagamitin yung oral deposition. Okay. So sabi ng Supreme Court, there are greater advantages in obtaining the facts and circumstances in a confronting examination, meaning oral examination, than in a written one. Okay. Stop muna. I will just explain. Written interrogatories. These are questions prepared by one party, of course, prepared by the lawyer, okay, to be answered by the other party. Okay? So, nakalista lahat. So, sa isang court submission, nakalista lahat ng questions. Kung 50 questions, kung 20 questions, lahat nakalista. Okay? Ang oral deposition, hindi siya nakalista. It will be an oral examination. So, obviously, sa written interrogatories, malalaman na nung kabilang party ano ba yung lahat ng questions. Okay? And then the one preparing the questions is very limited to what can be asked during that time. Hindi siya makakapag-follow-up questions. Why? Because follow-up questions are formulated based on the answer of the deponent. Since wala pang answer dahil written interrogatories pa lang, a list of all the questions, wala tayong masasabing may follow-up questions. In contrast, kapag oral examination or oral deposition, pwedeng magkaroon ng follow-up questions based on the answer of the deponent. Okay, so yun yung advantage ng oral examination. Now, mas effective ang oral examination or oral deposition kaysa sa written interrogatories in that there is a better opportunity to ask follow-up questions. Yung written interrogatories naman, mabibigyan yung deponent ng opportunity to study the questions and consult with a lawyer. Paano ba natin to sasagutin? Paano ko ba to isasagutin? And kung meron siyang gustong i-evade na na questions, pwede siyang mag-formulate ng evasive answers. Okay, so madedefeat yung purpose ng discovery. Kaya lang, ang written interrogatories, okay siya kung konti lang yung questions and you only want to get important factual matters. Yung oral deposition, importante siya if you want to get more comprehensive answers. All right. So ano naman yung advantage ng written interrogatories? Well, it is less expensive. Bakit? Because the parties will only exchange documents, written interrogatories, and answers to the interrogatories. Therefore, it's less expensive because they don't have to go to a certain place. Wala silang pamasaheng gagastusin. Wala silang time na i-suspend compared to oral deposition when they have to go to a designated place kahit malayo. They will incur expenses, transportation, accommodation, and the like. Now, interrogatories, mas simple rin siya kasi nga, you're only sending questions and answers to each other. Ang sa kapag depositions naman, yung mga advantage nito is mas searching. You can have more searching questions and better answers, and you have greater flexibility in framing questions, framing follow-up questions even. The deponent does not have the opportunity to study the questions in advance, to consult with his attorney before answering, and kung meron man siyang attempts at evasion, kung magaling yung nagko-question, persistent oral examination, kayang-kayang ma-meet yung attempts at evasion. Okay. So, kailan mo gagamitin yung written interrogatories? To compel admissions and the disclosure of major factual matters na hindi detailed. Kailan mo i-avail yung oral deposition? If you want detailed information. Now, isa sa mga reasons na sinabi ng defendant dito bakit hindi dapat nag-issue ng protective order yung trial court. I mean, bakit hindi dapat prevent yung deposition taking? What I'm saying is, bakit dapat hindi pinayagan yung deposition taking? Is because yung availability ng deponent to testify in court, nandiyan naman. Pwede naman siyang mag-testify in court. So bakit pa siya kukuha ng oral deposition? Sabi ng Supreme Court, that is not a good cause for securing a protective order. The fact that the witness is able to attend the hearing is not enough reason to prevent the taking of the deposition. Okay. And then sabi din ng Supreme Court, there is a difference between taking deposition and using the deposition in court. There is utmost freedom in deposition taking. Doon naman sa paggamit ng deposition, there are restrictions as to its use. Okay. Now, sinabi na ng defendant dito, kung papayagan natin yung deposition taking by oral examination, the trial court will not have the opportunity to observe the behavior of the deponent. The Supreme Court said, that's not a valid reason for preventing deposition taking because wala nang mangyayaring deposition. Because in all situations of deposition taking, the court is not going to be there. The judge is not going to be there precisely because the deposition is taken by another person who is authorized to administer oaths in another place, not in the courtroom. So this is not a valid reason. Otherwise, magiging walang visa ang deposition taking. All right, and then also let's talk about protective orders. Sabi, protective orders are issued to prevent a deponent, prospective deponent, from annoyance, harassment, or oppression. It's not enough to make that allegation. Supreme Court was was very quick to point out that there are requirements before a protective order of this nature can be secured. Una, there must be a motion made by a party or by the person who is sought to be examined. Number two, the motion must be seasonably filed. Number three, there must be good cause, which we have already discussed earlier. And number four, notice of such motion must be served upon the other party. And once a party has requested discovery, the burden is on the party objecting to show that it is not relevant and that it is covered by privilege. So it is not enough for a party to say, hindi tayo pwedeng mag-oral deposition kasi inconvenient. May inconvenient yung deponent, taga Manila siya, tapos isa-schedule ninyo yung deposition taking sa probinsya. Sabi ng Supreme Court, that's not enough reason unless you prove that it was done to annoy or harass the proposed deponent. Okay? And then, because of this, the Supreme Court, in the case of Fortune versus Court of Appeals and Intermerchant, stated that the trial court committed grave abuse of discretion in issuing an order that the deposition should not be taken in this case, and that the Court of Appeals erred in affirming the same. Now let's go to the second case, which is the case of Harry Go versus People of the Philippines. Itong case na to concerns depositions in criminal cases, conditional examination of witnesses. Actually, this case and the next two cases are all about depositions in criminal cases. So it will be good for us to compare how the Supreme Court decided these three different cases. Ito ay 2012 case. Ang issue that was presented to the Supreme Court is, if a prosecution or complaining witness is old and sickly, is a foreigner living in a foreign land, can his deposition be taken before the Philippine consul in the foreign land? How did the Supreme Court answer this question? Supreme Court said no. This will be in violation of the right of the accused to confront witnesses against him. The rules on criminal procedure require such witness testimony to be preserved by testifying before the Philippine court where the criminal case is pending. So sa case na to, makikita natin na iba ang provision ng civil procedure on deposition taking compared to the provisions or the procedure in criminal procedure on preservation of the testimony of a witness. So ano yung facts dito? 4 persons were accused of other deceits under Article 318 of the Revised Penal Code before the MTC of Manila. Upon arraignment, nag-enter sila ng plea of not guilty. Yung complaining witness, Li Wenping, is a frail old businessman from Laos, Cambodia. He traveled to the Philippines to attend the hearing, and then yung subsequent trial dates were postponed because of his unavailability. So, noong October 13, 2005, a private prosecutor filed a motion to take oral deposition of this witness, alleging that he was being treated for a lung infection at the Cambodia Charity Hospital in Laos, Cambodia, and that upon doctor's advice, he could not make the long travel to the Philippines. The Metropolitan Trial Court of Manila granted the motion after the prosecution submitted the medical certificate of the prospective witness. The RTC declared the MTC order null and void, holding that Section 17 of Rule 23 on deposition taking of witnesses in civil cases cannot apply suppletorily to criminal cases of this nature. There is a provision in the rules of court on the taking of depositions in criminal cases, and that is primarily intended to safeguard the constitutional rights of the accused to meet the witnesses against him face-to-face. Ito yung tinatawag natin na right of confrontation, meaning right to see the witness and right of the accused through his counsel to cross-examine the witnesses against him. Now, the CA, the Court of Appeals, upheld the MTC decision because no rule of procedure expressly disallows the taking of depositions in criminal cases. And that in any case, the petitioners, meaning the accused in the lower court, would still have every opportunity to cross-examine the complaining witness and make timely objections during the taking of the oral deposition, either through their counsel or through the consular officer who would be taking the deposition of the witness. The Court of Appeals denied the petitioner's motion for reconsideration. So ano ang reasoning ng Supreme Court dito? The Supreme Court said the procedure for testimonial examination of an unavailable prosecution witness is covered under Section 15 of Rule 119. Ito yung Rules on Criminal Procedure. The examination of witnesses must be done orally before a judge in open court. This is true, especially in criminal cases, where the Constitution secures to the accused his right to a public trial and to meet the witnesses against him face-to-face. So yun talaga ang right ng accused. Dapat makita niya face-to-face ang witnesses against him. This requirement is the safest and most satisfactory method of investigating facts. Why? Because it enables the judge to test the credibility of the witness by observing his manner, his behavior while testifying. But the rules of court recognizes certain exceptions, and this is in the conditional examination of witnesses and the use of their depositions as testimonial evidence in lieu of direct court testimony. Even in criminal proceedings, there is no doubt na pwedeng magkaroon ng conditional examination of witness, both for the benefit not only of the defense but also of the prosecution. The Supreme Court had the occasion to deal with this matter already in an earlier case, Viuda de Manguera versus Rizos, where the Supreme Court stated, as exceptions, Rule 23 up to Rule 28 of the Rules of Court provide for different modes of discovery that may be resorted to by any party to an action. Now, the intention of these rules are either to perpetuate the testimonies of witnesses or as modes of discovery. In criminal proceedings, under Rule 119 of the Revised Rules of Criminal Procedure, which took effect in 2000 December, these allow the conditional examination of both the defense and prosecution witnesses. So note, conditional examination, that's how this is designated or denominated. Now, dako naman tayo sa civil procedure. Under Rule 23 to 28, this allows the taking of deposition in civil cases, either upon oral examination or written interrogatories. Dalawa lang, oral or written. And before whom is the testimony, or rather, before whom is the examination made? Before any judge, a notary public, a person authorized to administer oaths. Where? Any place in the Philippines, when? At any time. Or kung nasa ibang bansa, excuse me, before any Philippine consular official, commissioned officer, or person authorized to administer oaths in a foreign country, with no additional requirement except that the other party should be given reasonable notice. Kaya lang, pagdating sa deposition in criminal cases, especially for prosecution witnesses who would foreseeably be unavailable for trial, the testimonial examination should be made before the court, or at least before the judge where the case is pending. This is required by Section 15 of Rule 119 of the Revised Rules of Criminal Procedure. So sa civil cases, any person authorized to administer oaths. Pero sa criminal cases, the examination should be made before the court or at least before the judge where the case is pending. So Anong sinasabi ng Section 15 ng Rule 119 ng Criminal Procedure? Sabi, when it satisfactorily appears that a witness for the prosecution is too sick or infirm to appear at the trial as directed by the court, or has to leave the Philippines with no definite date of returning, he may be conditionally examined before the court where the case is pending. Such examination in the presence of the accused or in his absence after reasonable notice to attend the examination has been served on him shall be conducted in the same manner as an examination at the trial. Failure or refusal of the accused to attend the examination after notice shall be considered a waiver. The statement taken may be admitted in behalf of or against the accused. So magkaiba. Tandaan nyo to because the subsequent rulings in the two cases that I have mentioned, we will be discussing later, the rulings are not the same. But anyway, let's bear in mind the philosophy behind conditional examination of witnesses in criminal cases. Dapat dun mismo sa court where the case is pending or at the very least before the judge that is hearing the case. And it should be in the presence of the accused. Or kung hindi man siya present, at least he was notified properly. Okay? So, since the conditional examination of a prosecution witness must take place at no other place than the court where the case is pending, the RTC properly nullified the MTC's orders granting the motion to take the deposition of Lil Wen Ping before the Philippine consular official in Laos, Cambodia. To take the deposition of the prosecution witness elsewhere and not before the very same court where the case is pending would not only deprive the accused of his right to attend the proceedings, but also deprive the trial judge of the opportunity to observe the prosecution witness deportment and properly assess his credibility, which is especially intolerable when the witness testimony is crucial to the prosecution's case against the accused. This is the import of the court's ruling in the case of Viuda de Manguera. Okay. Now, it is said that since the rules of civil procedure is made applicable in all cases, both civil and criminal cases, as well as special proceedings, the deposition taking before a Philippine consular official under Rule 23 should be allowed under the circumstances. The Supreme Court said the suggested suppletory application of Rule 23 in the testimonial examination of an unavailable prosecution witness has been categorically ruled out in the case of Viuda de Manguera. Okay? The conditional examination of a prosecution witness cannot defeat the rights of the accused to a public trial and confrontation of witnesses. This is provided for in the Constitution. Section 14 of Article 3 says, in all criminal prosecutions, the accused shall be presumed innocent until the contrary is proved, and shall enjoy the right to be heard by himself and counsel, to be informed of the nature and cause of the accusation against him, to have a speedy, impartial, and public trial, to meet the witnesses face to face, and to have compulsory process to secure the attendance of witnesses and the production of evidence in his behalf. After arraignment, trial may proceed notwithstanding the absence of the accused, provided that he has been duly notified and his failure to appear is unjustifiable. So naka-build in dun sa constitutional provision, the constitutional right of an accused to meet the witnesses face to face. Okay? This is the right of confrontation, which is part of due process. Now, in dismissing the petitioner's apprehensions concerning deprivation of their constitutional rights to a public trial and confrontation, the Court of Appeals opined that they would be accorded the right to cross-examine the deponent witness and raise their objections during the deposition taking in the same manner as in a regular court trial. The Supreme Court said no. The Supreme Court disagreed with this. There's a great deal of difference between face-to-face confrontation in a public criminal trial in the presence of the presiding judge and the cross-examination of a witness in a foreign place outside the courtroom in the absence of a trial judge. Citing the case of People versus Estenzo, the Supreme Court noted the uniqueness and significance of a witness testifying in open court. The main and essential purpose of requiring a witness to appear and testify orally at a trial is to secure for the adverse party the opportunity of cross-examination. The opponent demands confrontation, not for the idle purpose of gazing upon the witness or of being gazed upon by him, but for the purpose of cross-examination, which cannot be had except by the direct and personal putting of questions and obtaining immediate answers. There is also the advantage of the witness before the judge, and it enables the judge as a trier of facts to obtain the elusive and incommunicable evidence of a witness's deportment while testifying. So makikita ng judge yung behavior ng witness, makikita niya kung credible yung witness. The physical condition of the witness will reveal his capacity for accurate observation and memory. Kung tama ba, kung reliable ba ang kanyang sinasabi. So the right of confrontation is held to apply specifically to criminal proceedings and to have a twofold purpose. Number one, to afford the accused an opportunity to test the testimony of witnesses by cross-examination. And number two, to allow the judge to observe the deportment of witnesses. So in People versus Senieris, the Supreme Court explained that the constitutional requirement ensures that the witness will give his testimony under oath, deterring lying by the threat of perjury charge. It forces the witness to submit to cross-examination, a valuable instrument in exposing falsehood and bringing out the truth, and it enables the court to observe the demeanor of the witness and assess his credibility. As the right of confrontation is intended to secure the accused in the right to be tried as far as facts provable by witnesses, as meet him face-to-face at the trial, who give their testimony in his presence, and give to the accused an opportunity of cross-examination. It is viewed as a guarantee against the use of unreliable testimony in criminal trials. All right, so that is the tenor of the case of Go. The next case that we're going to talk about is the case of Mary Jane Veloso, and this is People of the Philippines versus Maria Cristina Serio and Julius Lacanilao, a 2019 case. What is the legal principle here in the case of People versus Serio? It is this: when a prosecution witness is imprisoned in a foreign country, his or her deposition can be taken in prison before the Philippine consul or his representative. And the trial judge who is hearing the criminal case in the Philippines, in accordance with Rule 23 of the Rules on Civil Procedure, applied suppletorily to the criminal case in which the witness testimony is needed. This does not violate the constitutional right of the accused to confront the witness against him. So ano naman yung facts nito? Maybe you read about this in the newspapers, maybe you heard about this on the radio or saw it on television or internet. Ito yung case ni Mary Jane Veloso. Mary Jane Veloso, together with Maria Cristina Serio and Julius Lacanilao, sila ay magkakaibigan at magkakapitbahay sa Nueva Ecija. Now, si Julius and Christina, they took advantage of the vulnerability of Mary Jane. Inoferan nila ng trabaho as domestic helper sa Malaysia. So si Mary Jane, kung ano man ang perang kanyang maipon, pati yung pagtitinda ng mga gamit, motorcycle ng kanyang asawa, inipon nila yung pera para makapagbayad sila ng placement fee. Eventually, si Mary Jane at si Christina umalis mula sa Pilipinas, pumunta sa Malaysia. Pagdating sa Malaysia, wala palang trabaho doon na nag-iintay kay Mary Jane. Sabi ni Christina, yung trabaho para sa'yo, hindi na available. So after spending a few days in Malaysia, pinadala ni Christina si Mary Jane sa Indonesia for 7 days, holiday daw, with a promise na pagbalik niya sa Malaysia, magkakaroon siya ng trabaho. Binigyan ni Christina si Mary Jane ng airplane ticket as well as a luggage, maleta, para dalhin niya sa kanyang trip sa Indonesia. Pagdating niya sa Indonesia International Airport, hinuli siya ng pulis kasi meron siyang daladalang 2.6 kilograms ng heroin sa loob ng kanyang bag. Na-charge siya ng drug trafficking before the district court in Indonesia. And si Mary Jane wanted comfort from her family. Sinabi niya na nakadetain siya sa Indonesia. Immediately, yung pamilya ni Mary Jane, kinonfront si Christina at sinabi instead of helping them, si Christina, imbis na tulungan sila, lalo pa silang trineten. Sabi, huwag niyong sabihin kahit kanino ang nangyari, lalo na sa media. Sinabi ni Christina na si Christina ay part ng international drug syndicate at gagastos sila ng milyones para mapalabas si Mary Jane sa preso. Kaya lang ang nangyari kay Mary Jane, na-convict siya ng drug trafficking and she was sentenced to death by firing squad. The decision was affirmed by the High Court and the Supreme Court of Indonesia. Mary Jane and 8 other felons were convicted of drug-related offenses. Pinadala sila sa prison facility sa isang island para intayin ang kanilang execution by firing squad. Yung 8 kasama ni Mary Jane na na-convict ay na-execute na by firing squad. Si Mary Jane ay nag-iintay. Nakadetain siya doon sa penitentiary. Meanwhile, sa Pilipinas, hinuli ng NBI Anti-Human Trafficking Division si Christina at si Julius. At they were charged with qualified trafficking in person in violation of the Anti-Trafficking in Persons Act of 2003. And then nakasuhan din sila ng illegal recruitment under RA 8042, known as Migrant Workers and Overseas Filipino Workers Act of 1995. Kinasuhan din sila ng estafa in violation of Article 315 of the Revised Penal Code. Nung binasahan sila ng charges, nag-enter ng plea of not guilty si Christina at si Julius. Tapos, sometime later, yung representatives ng Philippine Drug Enforcement Agency, Philippine National Police Crime Laboratory, and Department of Foreign Affairs pumunta sa Indonesia sa prison para interviewin nila si Mary Jane. Nag-execute si Mary Jane ng sinumpaang salaysay. At doon niya sinabi na inosente siya. Kinuwento niya kung paano siyang nirecruit ni Christina at ni Julius. Sinabi niya na nung nasa Malaysia, siya at si Christina ay nagstay sa isang inn. At kasi yung employer niya sa Malaysia, yung employer niya ay wala daw sa Malaysia. Si Christina ay may boyfriend na nagngangalang Prince na kausap niya by telephone. And Prince has a brother named Ike. So one day, Mary Jane and Christina nagpunta sa parking lot ng hotel at doon nila nakakita si Ike na nakasakay sa isang puting kotse. Sumakay sila sa loob ng kotse at binigyan ni Ike si Christina ng isang luggage. And then they went back to the hotel and Christina gave Mary Jane the luggage. Sabi ni Mary Jane, mukhang masyadong mabigat naman itong luggage na to pero wala namang laman sa loob. Eh sabi ni Christina, mabigat yan kasi bago. And then yung luggage ang ginamit ni Mary Jane papunta sa Indonesia. And it was only after she was apprehended at the airport na na-realize niya na meron palang prohibited drugs na nakatago doon sa ilalim ng luggage. So dahil sa kanyang sinumpaang salaysay, ni-request ng Philippine government, yung Indonesian government, na wag i-execute si Mary Jane. Sinabi ng Indonesian government, sinabi ng Philippine government na yung recruiters and traffickers ni Mary Jane ay nakakulong na at kailangan nila ang testimony ni Mary Jane para ma-prosecute si Christina at si Julius. Now, a few hours before the scheduled execution of Mary Jane, the President of Indonesia granted Mary Jane a reprieve. And the Cabinet Secretary of the Indonesian government informed the public that the President received reports about the ongoing legal proceedings in the Philippines concerning Mary Jane at na yung mga recruiters niya ay nasa kustodiya ng police. So dahil dito, meron tayong Treaty on Mutual Legal Assistance in Criminal Matters entered into by Southeast Asian nations, okay, the ASEAN Mutual Legal Assistance Treaty. Yung Indonesian authorities, dinefer o sinuspend nila yung execution ni Mary Jane para magkaroon siya ng pagkakataon na ilahad ang kanyang kaso laban kay Christina, Julius at Ike, who were responsible for recruiting her and exploiting her to engage in drug trafficking. Kaya lang may kondisyon na binigay yung Indonesian authorities sa pagkuha ng testimony ni Mary Jane. Una, dapat hindi lalabas si Mary Jane sa detention. Doon lang siya sa Indonesia. Pangalawa, bawal ang mga kamera. Pangatlo, walang abogado na darating. Yung abogado ng mga partido. Number 4, questions to be propounded to Mary Jane shall be in writing. After that, nag-file ng motion for leave of court to take the testimony of Mary Jane Veloso by deposition upon written interrogatories. Okay, sabi ng state, ng prosecution, yung taking ng testimony ni Mary Jane through the use of deposition upon written interrogatories is allowed under Rule 23 of the Revised Rules of Court. Ito na naman, ina-apply na yung provisions ng civil procedure because she is out of the country. Hindi siya pwedeng humarap sa court sa Pilipinas, syempre because she was imprisoned in Indonesia. According to the prosecution, Rule 23 of the Rules of Court will apply suppletorily in criminal proceedings. And the use of deposition upon written interrogatories in criminal cases is not expressly prohibited by the rules of court. In fact, pwede namang ma-dispense ang direct testimony under the rules of environmental cases and the judicial affidavit rule. Sabi rin ng OSG, Christina and Julius will have the opportunity to examine Mary Jane by propounding their own set of written interrogatories through the designated consular official who will be taking the deposition. Hindi naman sila pinagbabawalan na mag-object sa questions and answers. Ngayon, si Christina at si Julius, nag-object sila dun sa motion to take deposition. Ang sinasabi nila, yung deposition dapat gawin before the trial, not during the trial. At saka yung provisions ng Rules 23 and 25 ng Rules of Court, hindi pwedeng ma-replace ang actual testimony ng witness sa open court. Kaya yun ay ginagamit lamang sa civil cases, hindi sa criminal cases. Kapag ginamit ito sa criminal cases, it will violate the right of the accused to confront the witnesses against him, which is a right that they have under the Constitution. And sinabi rin nila, yung reliance on the rules of procedure for environmental cases and judicial affidavit rule, hindi applicable. Kasi, i-cross-examine pa lang yung mga affiants. Okay? Now, anong sinabi ng Regional Trial Court? grinant ng RTC yung motion ng prosecution pero may mga kondisyon. Okay? So, sabi ng RTC, considering that the prosecution has already submitted their proposed questions in the written interrogatories, the accused, through counsel, is given a period of 10 days from receipt of this resolution to submit their comment to the proposed questions on the deposition for the witness Mary Jane Veloso, and the court shall rule promptly on the objections. In other words, binibigyan ng RTC ng opportunity yung accused to comment or to object to the proposed questions. The second, sabi ng RTC, the court shall schedule the taking of the deposition in Indonesia, which shall be presided by the undersigned trial judge. So yung judge hearing the case will be the one who will go to Indonesia to hear the deposition. Okay? The final questions for the deposition shall be propounded by the consul. The answers of the deponent shall be taken verbatim by a competent staff of the office of the Philippine Consulate in Indonesia. Another condition, the transcribed copy of the answers of the deponent shall be furnished the accused through counsel, who shall thereafter submit their proposed cross-interrogatory questions to the prosecution within 10 days from receipt. So makikita ninyo sa order ng RTC na built-in doon yung right to ask cross-examination questions. Another condition, the prosecution is given the same period of 10 days from receipt of the proposed cross-interrogatory questions of the defense, stating the grounds of the objections, and the court shall promptly rule on the objections. Another condition, the court shall schedule the conduct of cross-interrogatory questions for the deposition of Mary Jane Veloso in Indonesia, which shall be presided by the undersigned trial judge. And then, meron pang condition, unless the prosecution opts to conduct written interrogatories, the testimony of Mary Jane Veloso by way of deposition upon written interrogatories shall be deemed terminated. So ang ganda ng order ng regional trial court judge kasi yung mga protections na binibigay ng Constitution sa accused are built into the order. Kaya lang, yung dalawang accused, si Christina at si Julius, nag-file ng motion for reconsideration and to suspend period of time to file comments to the proposed questions. And then inakyat nila yung case before the Supreme Court through a petition for certiorari. The una, inakyat nila before the Court of Appeals. All right? And then, so the Court of Appeals made a ruling. Sabi there was an abuse of discretion on the part of the trial court. Dapat daw, hindi pinayagan yung ganong klaseng deposition taking. So ngayon, nandito na naman sa Supreme Court, and the issues raised before the Supreme Court are as follows. Whether or not the Court of Appeals erred in granting the writ of certiorari, and whether Mary Jane's testimony may be validly acquired through deposition by written interrogatories. What did the Supreme Court say? Okay, the Supreme Court said that it was proper for the regional trial court judge to allow the taking of deposition in Indonesia because of the peculiar circumstance of the witness, si Mary Jane. There is no showing that the trial court abused its discretion. In fact, the trial court, sabi ng decision ng appellate court, the trial court merely erred. Hindi sinasabing there was an abuse of discretion or much more grave in applying Rule 23 ng Civil Procedure instead of Rule 119 on Criminal Procedure. Okay? Under Section 15 of Rule 119, requiring prosecution witnesses who are sick or have left the country without any date of return to deliver their testimony in open court, hindi yun pwedeng i-apply dito sa case na to because of the peculiar situation of Mary Jane. Mary Jane Veloso is the private complainant in the criminal case. Her situation as a death row convict incapacitates her from making decisions to take the witness stand. The decision to testify and the manner by which her testimony is to be given depends on the Indonesian authorities before whom she was sentenced to suffer the supreme penalty of death. Second, dahil hindi pwedeng i-apply yung Section 15 of Rule 119, yung sa Rules of Criminal Procedure, it is appropriate to apply Section 23, which is for civil. It is appropriate to apply it in a suppletory manner by taking the deposition of the private complainant upon written interrogatories. And then sabi rin ng Supreme Court, the deposition sought by the prosecution is specifically aimed at perpetuating the testimony of Mary Jane, the private complainant, and said deposition may be allowed at any stage of the proceedings, even on appeal pursuant to Rule 24. Okay, and then also, the offense involved in this case, qualified human trafficking, is a major transnational crime committed across continents. Hindi katulad ng previously cited case of Go, which we discussed earlier, which is estafa and other deceits. Ito, major transnational crime. It cuts across borders. It is a principal policy concern among nations. And the prosecution should not be denied the opportunity to prove its case, assuring the global community that the Philippines is committed to fight against such modern menace. Meron pang sinight ang Supreme Court dito, yung dying declaration. Sabi ng Supreme Court, yung testimony ni Mary Jane Veloso would be almost equivalent to a dying declaration kasi she was already sentenced to death. And the only reason why she was not executed is because of the clemency that was given to her because of the pending case that she is facing. But to all intents and purposes, the philosophy behind testimony in a dying declaration is there. Kasi nga, pati yung mga kasama niyang 8, they have already been executed. And because of that, there is no probability that she will not be telling the truth. Okay, so I think that's also one important consideration. And therefore, the Supreme Court said, yes, it's proper for Mary Jane Veloso to have her deposition taken in Indonesia according to the orders of the judge. Inaffirm ng Supreme Court yung resolution ng judge with a modification that the deposition will be taken before our consular office and officials in Indonesia pursuant to the rules of court and principles of jurisdiction. Okay, so for now, we're going to be ending here. The next case of Hubert Webb, we will be discussing in part 2 and together with other principles and rules on modes of discovery and deposition taking. This is Attorney Chato. I am the organizer and one who is presiding over this website, Easy Law Online. And thank you for attending our webinar. I will be welcoming your questions. You can send me your questions by email at easylawonline@gmail.com. Again, easylawonline@gmail.com. Meanwhile, wait for the next part of this video in which we will continue the other discussions about modes of discovery, including depositions. I would like to share my favorite Bible verse with you before ending this, and that is from Micah chapter 6, verse 8. Do justice, love kindness, and walk humbly with our God. See you next time.